Buenos días a todas y a todos.
Good morning to you all. So let's start with the final speaker, the last speaker of this seminar, the European Projects, Modernization and Governance in a Plural Framework with Shared Values and Goals in the framework of the Charles V or Carlos V European Award-MARCELINO, OREJA. The last speaker today is Alejandro Sánchez Frías, Doctoral Research Fellow in Public International Law and International Relations at the University of Malaga. And this is like the continuation of the previous speech because it's law again. We are talking about law in the European Union. And he will be introduced by Teresa Freixas, Professor of Constitutional Law at the Autonomous University of Barcelona, and Jean Monesha at Persona. So I will now give the floor to Teresa. Thank you, Teresa, again for being with us today.
Muchas gracias de nuevo por...
Thank you very much once more for everything. Being here means to me at this very interesting seminar. So now I have to give the floor to Alejandro Sánchez Frías, Doctoral Research Fellow in Public International Law and International Relations at the University of Malaga, from which he received a Bachelor of Laws with honors and a Master's degree in Legal Practice at the University of Salamanca, and a Master of Arts in European Union Studies from the University of Salamanca, and an LLM in European Law from the College of Europe. He has been a visiting researcher at the Max Planck Institute for Comparative Public Law and International Law at Heidelberg. And this is linked with terror. They will be talking about the framework created by the European Union, which is a multi-level European context, a multi-level law context, legal context, with several levels. The parliaments, national parliaments, European Parliament, and regional parliaments with lawmaking competencies, but also multi-level at the executive branch. However, we cannot see that multiplicity of levels at the judicial branch because we see a diversity of dialogues. Dialogues between courts. There can be internal dialogues through the appeals processes, the question of constitutionality, or internal courts and international courts when we go to the Hague Court or the Strasbourg Court. And it would be all the more intense if the European Union ever joins the International Convention on Human Rights. That will be a more intense dialogue than the one that is taking place now. In the European Union, we talk about criminal cooperation because we don't have a European criminal code, but we do have some criminal laws in Europe. And we also do harmonization of criminal crimes, the criminal law text, the criminal legal text in the countries change based on this harmonization. We also have the European Court's case laws. And then we also have specific instruments for judicial cooperations. They are complex and they have explained some problems. For example, the European Order for arrest and delivery. So we need to understand whether it can be used as such or if we need to interpret it. It is the European arrest warrant, because if it becomes totally ineffective, states will refrain from using it, especially since there has been no harmonized transposition of the in absence trials regulation. We haven't dealt with it in depth, and we need to understand how it works. The protection warrants, the victim protection warrant, victims of all types of crimes, with some specificities for terror victims or victims of violence or gender violence victims. It is an instrument that needs more pedagogy for it to work. I've been to Poland and I've had to negotiate its application to the victims of gender violence with an archbishop, because in Poland, people who have that problem, who are victims to that type of crimes, don't go see a lawyer, they go see a priest. So we need to understand how to train judges in applying these types of norms, rules. Or, for example, the investigation warrant. So even if we have an important reserve for sovereignty, in this type of judicial proceedings, we nevertheless have to be able to understand that sovereignty in the European Union with the free movement of people in capitals and avoid misinterpretations of them. So we need to understand how we make progress in it, because the integration process needs for a criminal guarantee that is more or less harmonized for the ensemble of the member states. So I think this is just appropriate. So thank you for choosing that topic in your PhD dissertation and your research that you're going to present today. The fact that we don't have a common criminal code doesn't mean that we don't need to pay attention to it.
Bueno, pues muchas gracias por...
Thank you for the introduction. I would like to thank also the European Academy, European and Ibero-American Academy of Yuste. Since I am the last speaker, I need to fulfill the expectations. I want to live up to the expectations and not deliver to you speech of less quality than the speeches of my colleagues. So the topic I've chosen is a crisis in the criminal law of the European Union, signal for us to reinforce the commitment with the fundamental rights and the European values. So I want to start by saying, as Professor Ebert said yesterday, the economic origin of the integration process. So after World War II, the founding fathers of the now European Union had the idea of having a strong economy, an economy that could guarantee peace. So a series of resources were devoted to that, with the creation of the control of a high authority to control steel and coal, the big resources there. But then the consolidation and integration processes became wider and extended to free movement of people, goods and services. This is what we call the internal markets. So we have the opportunity also to see over these days that this integration process has been making progress from what the founding fathers thought. Nobody would think that we could be talking today about banking union, border cost, or the withdrawal of a member state. So all this is the positive version of the European Union, the most favorable one of the European integration process. But this integration also has its setbacks or negative consequences. So I'm saying that since people move freely, criminals also move freely. So we have transnational criminality, but the jurisdiction of the member states still stays within the borders of each nation. Criminals don't have borders, but countries do. So the Maastricht Treaty in 1992 started the first cooperation for justice and inner affair matters. And after that, we had the so-called inner space for justice and freedom. So this is the combination of effective safety, collective safety, and individual liberty, individual freedom. So in times of crisis, this balance becomes altered towards the security, the safety, and against the individual freedoms. And for example, at times of crisis are the terror attacks or the terror threats that we had recently. So the aim of my talk is to see how this imbalance creates lack of confidence and lack of trust in international cooperation. And that's why I will analyze the basic aspects of the European criminal law and how it relates to the individual freedoms and the fundamental rights. And then I will talk about the case law of the European Union Court of Justice that is very rich in its reasoning. So I will start with the European law. So it is based in two basic axes, mutual recognition and harmonization. It can be found in Article 82 of the Functioning Treaty, the recognition of judgments in terms of criminal law among the member states. But for those of you who don't know about this, you might think of the internal market. The origin of this principle, the mutual recognition, is also found in the inner market with the famous Cassis de Diron sentence or judgment. But we found it in the beginning of the European Union. It was a French company that manufactured a product called Cassis de Dijon and tried to market it in Germany. What happened in Germany? That they have a purity law, a purity rule for that type of spirits, and they said that it didn't have enough purity for it to be sold in Germany. So, and they said this is to protect our consumers. Allow me to mention this, even if it sounds weird. When I was talking about mutual recognition, it's more or less the same. The recognition of other judgments and rulings, for example, from Spain in Belgium, in the same way that you have to recognize a spirit that can be legally manufactured and marketed in another member state. The same goes for rulings that need to be recognized in other member states. So the main principle for this is, or the main objective, is a fast and efficient cooperation between the member states while maintaining the national rules. And this is then extended to the European space for safety and justice, but with a difference. When we talk about the internal markets and the principle of mutual recognition, this is done to guarantee the individual freedoms. For example, think about the example of the Cassis de Dijon, the Dijon Cassis. The manufacturer needs to be recognized in the countries where his product needs to be recognized or marketed. What happens then in the safety and justice European space? The principle of mutual recognition is used in order to constrain the individual liberties, while in the internal market it is used to extend the individual freedoms. So it is the same thing, the internal market. Well, sorry, the mutual recognition is the same in the internal market and in the European space for safety and justice, but it serves different purposes, opposing purposes. So why is it useful? Well, it was used for countries to trust each other. This is difficult in the Lisbon and in the criminal spaces because, as one expert said, it is difficult to assess how member states use this type of solutions to banish other members. So as Teresa Frías was said, the more differences between the member states, the less trust they will have between them or among them, because that way it will be more difficult for them to recognize a ruling coming from another member state. So what happens? Next, we have the second pillar of the European criminal law, harmonization. So since we have several or different criminal laws, we are trying to harmonize the law and then share the monopoly. And it is done through European directives that set out the basic rules for substantive law or substantive principles in the criminal law. For example, human trafficking, terror, child labor, etc. With several common definitions and softening or definition of the minimum sentences. Within this mutual recognition, we have to pay attention to the case law of the European Court of Justice so that we can see how the individual freedoms are restrained in favor of the collective safety. We don't have much case law, but everything turns around the main instrument, which is the Euro warrant or the arrest detention warrant, which is a warrant that is issued by one of the member states for a person to be arrested and delivered to another member state, which is the extradition, as it was called, but it is now more efficient. But a Euro warrant can be denied. Article 3 and 4 of the framework decision collects a few reasons why they can be extradited. For example, if there is amnesty for that type of crimes, if it's a minor, if the person is a minor, or if the crime has expired or is no longer valid, among others. But what about the fundamental values? Can a Euro warrant be denied because there is a suspicion that some rights are not being complied with in the country of origin? For example, can a Euro warrant be denied to Spain if other countries consider that Spain is not maintaining or guaranteeing the fundamental rights? So if we pay attention to the case law, we have to pay attention to the case law before Lisbon and after Lisbon Treaty, because the case law was approved. It was approved in Nice in the year 2000, but it was a more it wasn't legally binding.
En la jurisprudencia pre-Lisboa se realiza esta...
So in the case law before Lisbon, we needed to understand, this question was introduced, can a Euro warrant be denied? The Court of Justice said it is up to the issuing state to control the respect of the fundamental rights. A Euro warrant can only be denied on the grounds on Article 3 and 4, which doesn't cover, we don't cover the fundamental rights. So we presume high respect of the fundamental rights of the member states. So this needs to be guaranteed. The effectiveness of the European criminal law needs to be guaranteed. So this first rule is clear. So then we think whether this could change after Lisbon, once the Lisbon Treaty came to force. And this Charter of Fundamental Rights is no longer a legal document. It has the same value, it has the same importance as the treaties. So we might think that the effectiveness of the warrant can also change. So we make the question, and we use the ruling of the Radu case with Romania. And even if the general lawyer, the general advocate, Tapston, said that, in fact, fundamental rights should always be taken into account when denying Euro warrant, the Court of Justice remained loyal to case law before Lisbon. They said that the freedoms should be restrained for the sake of the collective safety. And now we have a ruling that I would rather not comment, which is the Meloni case. And I said that, and I say that constitutionalists have commented upon it because it was the first pre-judicial question commented by in this case. So we have Mr. Meloni, who commits a crime in Italy and then flees to Spain. So a criminal procedure is initiated in Italy, and he is judged in absentia. So he comes to Spain, and a Euro warrant is issued by Italy to Spain, and then the Spanish judge has a dilemma. Because if he interprets Article 24/2 of the Spanish Constitution, it wouldn't be possible for him to deliver that person if he didn't have the right to an appeal, which in Italy was simply not possible. So the Constitutional Court of Spain then considered the denial of a Euro warrant based on the interpretation of the Article 24/2, the guarantee of fair proceedings. And then the European Court said, no, you can't. Applying in this sense the constitution of the member state and the interpretation of the guarantee of procedures would lead to questioning the uniformity of the fundamental rights defined on that framework, and it would contravene the principles of trust and mutual recognition that we want to reinforce. And that would question its effectiveness. So no, the interpretation of Article 24 of the Spanish Constitution cannot be used because it is more protective than the Italian legislation and than the European Charter. And now I'm going to talk about...
que es el dictamen 2.13
So, and now
de justicia
I would comment on the 2013 ruling. It is a quite long ruling, but I want to focus on just a small part of it. When the union, the law of the union is applied by member states, they need to presume that other member states will respect fundamental rights. We have to presume it, so that it is forbidden to them to demand other member states to exert level of protection that is higher than the level of protection set up in the European Union. And also, they have to presume that fundamental rights have always been the ones that have been guaranteed by the European Union. So we have two negative obligations for the member states. The first one, when we receive a Euro warrant, we cannot ask the issuing state a level of protection of fundamental rights that is higher to the level of the European Union. And secondly, we cannot ask for, or we cannot control the protection, the guarantee of protection of the European fundamental values. This was widely criticized by the doctrine, especially because in the investigation warrant, the fundamental values are recognized to be a cause for denial, and this is a very similar position to the one of the Euro warrant, but I have to say that this has been the position of the court, the European Court. So this position of the European Court can be defended if we are at a general scenario of protection of fundamental values in the member states. What happens if we have this current scenario with all the crises and all the context have been mentioned here of the European values and fundamental values? If there is the pressure of the migration flows, the 3rd of June, an appeal was lodged before or in the European Court of Justice by a group of French lawyers for crimes against humanity, referring for the Frontex agency. What happens if there is an opposition to the rule of law in Poland, or internal secession or withdrawal of member states? So presuming the effectiveness of the European criminal law is much more complicated on the side of the European Court. And this is what I'm going to talk about next.
La primera situación que
So the first crisis I want to mention is the situation of prisons in Hungary and Romania. For many years, the European Court of Human Rights has been condemning these countries for overpopulation in the prisons and violation of the human rights and degrading human rights. And the court in Bremen also, the ruling on the Aranjosi case. The same question again. If I am a German court, a German authority, and I receive a Euro warrant from Romania or Hungary, and I suspect that that person is going to be sent to a prison with overpopulation and subject to degrading or inhumane treatment, I can presume that there will be a violation of the fundamental rights and argue that a denial of the Euro warrant is of the essence. But I need to pay attention to the details. In the ruling 2/13, mutual recognition can be limited in case of exceptional cases, exceptionality. So, and then it recalls that the prohibition of degrading treatment has an absolute character.
Y aquí el Tribunal de Justicia, por primera vez,
Here, the Court of Justice recognizes for the first time that the state of execution, that was Germany in this case, can control the protection of fundamental rights in the emitting state, Romania or Hungary, when they have serious doubts that there may be systemic deficiencies and generalized deficiencies in protection of fundamental rights in that particular state. They may exchange information about the situation of penitentiary conditions and then get to conclusions. This is the first change in case law in this matter, which has been lauded by doctrine because there is a balance between fundamental rights and the pan-European law. It allows the execution state to, or executing state to control, and there has to be deficiencies in the emitting state regarding the fundamental rights protection. This is a balance that didn't exist before. Which is the second situation? It has been mentioned in other presentations here of the judicial reform in Poland and the rule of law. Don Marcelino spoke about it, and I don't want to make myself full of myself, and the Commission of Venice goes against, says that the census goes against the judiciary rules, and the reform, according to all these reports, should not be implemented. Don Marcelino referred to the violation or serious breach of the rule of law. You explained this already, but I'm going to really focus on one judgment that refers to Poland, and that has to do with activation of Article 7 of the Treaty of the European Union. In the Eleno case of March 2018, it is submitted a Euro warrant to an Irish court from Poland. What is the doubt with the condition of this person who is being requested? Can I hand that individual when I have serious suspects of violation to the effective respect of law when there is no this situation in Poland? Can I apply that Euro warrant? Then the Tribunal of Justice of the European Union followed what happened in the case Ranjosi in Romania and Hungary. That risk of the effective guarantees can be deduced, for instance, that the Article 7 of the European Union Treaty has been activated, which is an alarm that is not being respected, that there are violations, systemic and generalized violations. So Ireland could exert that protection of fundamental rights as an executing country and then refuse or suspend a European warrant. So the consequences of Article 7 goes beyond the suspension of votes in the Council. If member states do not trust in you because you don't respect the European values as the rule of law, then cooperation is not applicable as well, because you're not playing according to the rules of the game. So this could be seen in a case like this one of Poland. A third case, which in principle I was not thinking of introducing, because since the other one was on the Brexit, I decided to include it. The crisis that everybody knows about the withdrawal of the United Kingdom from the European Union. It has been in the media. Ireland, Gibraltar have been mentioned, the importance for future application of freedom of movement, what will happen with the next prime minister, who might be a male, what is the consequences about the cooperation, the criminal cooperation with member states? What happens with European arrest warrants that the United Kingdom has already dictated? This is the question that the tribunal is facing now with the case RO, the initials. In 2016, Ireland receives orders from the United Kingdom on an individual that had been condemned for assassination, rape, and for provoking for arson. Then the case is submitted to the Irish courts, and this person was legally very well defended. First, the criminal law lawyer knew very well what the Alanjosi result had been, and he says the prisons in Britain are not in good conditions. They're degrading and treatment in there, or they are crowded, etc., etc. So all the court in Ireland reaches the conclusion that fundamental rights in the United Kingdom are respected. That was the first argument. The second argument is that the defense said, if my client goes to the UK, there is the risk that he should fulfill their condemnation in a prison of a country that by then will not be a member of the European Union, which will not be under the regime of protection of the Charter of Fundamental Rights of the EU, and all the time that has been detained in Ireland will not be able to be applied for discount in the full term of his sentence. The position of the Court of Justice of Luxembourg has been quite conservative. On the one hand, says that the prevailing norms have to be respected until the UK leaves the EU in an effective manner, taking into account the potential transitory dispositions. What is important now is exceptions, because they say we do not rule out the suspension or rejection when, in Alan Jossi's case, serious reasons that in the future the rights protected by the Charter of the EU will not be respected adequately. How do we analyze in the future whether they are going to be respected or not, those rights? Well, the Court of Justice notes two things: the national protection level of the fundamental rights and the participation or not in the Convention of Human Rights. So there were apparently threats of leaving the Convention of Human Rights because it restricted their sovereignty. Possible consequence of those threats being serious, the judge in Ireland may say there is a risk that the UK leaves the Convention of Human Rights. That is a serious reason that in the future there won't be the protection guaranteed, the protection of human rights guaranteed. Then there's another position of the UK of trying to reform the Human Rights Act to restrict it. If that is carried out, there will be two reasons so as to see that the guarantee of the protection of the human rights in Britain won't be that well implemented, and this will justify not to concede the Euro warrant coming from Britain, something that has been used quite frequently by Britain. So once again, we see the consequences that a situation of crisis may have for the criminal law, the European criminal law, and the cooperation between member states. And up until now, I have spoken of the principle of mutual recognition, which was one of the axes, and then I want to turn briefly to the second, which is harmonization. We try to define crimes and other provisions, and we turn to the directive of fight against terrorism related to foreign terrorist combatants, which has been much in vogue with the Daesh. They are nationals that go who travel to Iraq or Syria and that return, and then they make their attacks. This happened in November 2015 in the attacks in Paris, which was the international response in this matter. At the level of the UN, the 2178 resolution of the Security Council, which is to criminalize the traveling, financing, organizing these nationals. This is in also the Protocol of Riga, where it is criminalized the traveling or receiving passive recruitment or finance in order that they may be trained to become terrorists, and the financing of those activities. And then the European Union in 2017 picks up from both previous things, and the directive of fight against terrorism is including the Riga Protocol, and it includes minimum sentences in this case, which has been the response by the doctrine, that it has a disproportionate impact in that balance between the protection of fundamental rights and the guarantee of the security. I don't know whether you have seen Minority Report with Tom Cruise, where pre-crime is being dealt with, where the crime has not been committed, but it is intended that it is foreseen that it will be committed, because it is being condemning people, because people access web pages, are buying tickets to states where you have to really prove that you are traveling for legitimate purposes. For instance, to work in NGO or wherever. So it should be the police that should investigate this, and not be a prerequisite that you have to prove yourself as an individual. So it is being criminalized, legitimate behaviors, access to the web or buying tickets, and that could be applied to situations that may affect religious or press freedom. This is the general criticism. In the case of the directive against terrorism, the particular criticism has been that in general the European Union has as a practice to carry out an impact study on fundamental rights of the norms that they are going to pass. In the case of the directive against terrorism, and notwithstanding the fact that the European Parliament has insisted on that, it didn't make the impact study and how this directive could impact on the protection. The Commission intends not to be discussed by the judge of the tribunal the proportionality of the norm, because this is the main reason of this kind of a study. But in this case, the study of the impact was not carried out. And they argued that it was a problem of emergency. It was so serious, the presence of foreign terrorist combatants, that it was necessary. When you have 2 years for transposition or transferring to the national and domestic law, it wasn't that urgent, or it wasn't a situation of emergency, in fact. As final reflections, and taking into account what has been presented here, we are in front of different crises that put in question European identity based on common values and protection of fundamental rights. I want to quote Pinto de Albuquerque, one of the judges, in one of his reserved votes, where he establishes that in a chaotic Europe and fully polarized, and with the crisis of traditional political parties and new populist movements, and within a crisis of economic nature and external wars, putting the issue in homo homini lupus perspective, and on the regnum lupus as well, alienates Europeans between each other, and this goes against the Council of Europe and EU. This fear has allowed for deportations, purges, and discrimination against them, or even assassinations authorized by the state. In the European criminal law, we see also the crisis, the cleavage between the balance of liberty and security towards security, both in the member states and in the European institutions when they elaborate norms. But we could also appreciate at the same time, and this is reason for hope, the evolution of the case law in the Court of Justice of the European Union. There is not mutual trust. It shouldn't be mistaken as blind trust. There is no blind trust. Member states should merit their trust and cooperate in criminal matters, protecting fundamental rights. So we see a change of mentality from the effectivity or effectiveness, sorry, of a European criminal law in every judgment based on the results that the person is detained and handed out. It is changing towards efficiency of the European criminal law, which is an ability to reach the achievements, but taking into account the means and not just the results. And here, the means that guarantee the successful cooperation in criminal area is to defend the human rights, the fundamental human rights, and the European values. That's all. Thank you very much.
Por tu exposición. Muchas gracias por el ajuste del tiempo.
Thank you for your presentation and for being on in time, which today is particularly important. That one of the last phrases, the difference between mutual trust and blind trust. When we are in the judicial area, that has to respond to indicators which inspire that trust, that mutual trust. You have spoken of the jurisprudence of the European Court of Human Rights. There is an experience in that court where you can see the states through the annual reports and other every 5 years or every 10 years, which are the states that are more or less condemned. We did a job with the University of Valladolid comparing 5 European states in order to see which was the health in the face of the Convention of the Human Rights, and Spain was one of the least condemned, and this should be highlighted to evaluate this mutual trust, not blind trust. If we say that we respect human rights here, is because there is clear elements of proof that there is an organ, a body that controls the guarantee of those. In the Council of Ministers of the Council of Europe, there are also interesting indicators, and I would suggest you to take into account the work done by the Agency of the Human Rights in the European Union. They have done important works where you can see whether harmonization is taking place among member states and how that entails a better guarantee of all the rights, because the procedural guarantees not only protect the effective fair process, fair trial and so on, but it's also a guarantee that the other rights are being respected as well. It is a very interesting topic, and I think you pose a number of problems that are also the future of this European Union. It will work, the European Union, if that trust, the mutual trust, functions. Otherwise, we will be in a system where the lack of trust will make the states to refrain from cooperating, and then ending the basic principle of cooperation that is the one that rules us so far.
Muchas gracias por todo.
Thank you very much for what you have said. Now we will give the floor to the audience. Marcelino Oreja has the floor.
I want to congratulate Alejandro. And also would like to ask the director to forward this to the Minister for Foreign Affairs, because of course we've been talking about this among some of us, and I think you have exposed it with such an accuracy and clarity that they should have this. And I am sure, I am aware that the Minister is really interested in this and interested in what the he knows what the European and Ibero-American Academy of Yuste does, but he would like to receive this document. So I would like the director to consider forwarding this document to them. Thank you.
Por favor. Tiene usted la palabra.
Who wants the floor? Someone in the second row? Well, Alejandro, congratulations. You've made a brilliant presentation, but since this is the third day in the seminar, and well, I think you have mentioned Carrias Puigdemont, and purely based on legal criteria and the explanations you've made and the evolution of it, I don't understand why Puigdemont is still in Brussels, so allow me to ask you about it. This is a challenge that I throw to you if you want to accept it and reply to it. Thank you, Alejandro. Well, thank you for the question. I was thinking that someone would certainly ask about it, and I haven't mentioned him on any occasion because since there is no ruling from the European Court of Justice about him, I couldn't mention it. But of course, you're right. This case would be the same that would be applied to him. I can briefly mention what happened with the Puigdemont case. I don't want to talk about ideological or political issues. But from a legal point of view, well, Spain withdrew the Euro warrant in the case of Belgium, but we kept it. It was kept in the case of Germany. I don't know if you remember that the Belgian authorities asked about the state of prisons in Spain. So it's similar to the Alain Josi case. But going back to Germany, so the Euro warrant is applied and it was accepted in the Holstein, in the court of Holstein, but they say that they will not extradite Puigdemont. So it's weird that the Minister for Justice in Germany said that Puigdemont wouldn't be extradited because the Euro warrant wouldn't be applied. So that raises all the alarms. I'm not talking about Poland, but Germany, if someone feels interested about it. Someone said recently that the German judges cannot ask for Euro or so German prosecutors are not allowed to ask for the Euro orders, Euro warrants. So in any case, they have to comply with the framework regulation on extradition with a list of 32 crimes, and there is automatic cooperation for all of them. As soon as you find one of these crimes, the Euro warrant is applied and the cooperation is almost automatic. What happens with the rest of the crimes that are not part of those, the list of the 32 crimes? So we have a basic principle of criminal cooperation, which is the principle of double criminality. So it means that it has to be a crime both in the issuing country and in the executing country, Spain and Germany. So if I'm right, Puigdemont was accused of embezzlement and rebellion. So rebellion is not part of the 32 crimes. So the German judge compared the situation in Spain, and he had to decide whether that would be considered to be a crime in Germany. And in Germany it was treason, but in Spain it was rebellion. And to find a comparison in Spain, the same rebellion case was typified after the coup d'etat of the 23rd of February. But treason in Germany was meant for the potential spies and enemies of the Democratic Republic of Germany. So even if they could be similar, the context in which the treason and the rebellion crimes were approved are totally different. So the German judge could have made one thing, could have done one thing, to simply say, well, a rebellion crime in Spain and a treason crime in Germany are more or less similar, so that's it, I will stop at it. I am recognizing that the double criminality principle exists. But the problem of Germany and the German judge in this case was that the analysis he made was totally substantive. So he examined all the evidence sent by the Spanish authorities, the videos, and the amount of violence found in the videos, and they said the amount of violence was not enough according to the German laws to consider it to be a treason crime. So he analyzed the Spanish case in depth. So what do you think if you analyze, if you know that he analyzed the Spanish case and all the evidence, we might think that he doesn't trust the Spanish authorities. So there is an invalidity of that principle. So instead of trusting that Spain was doing the right thing, he was judging the case as if the case had taken place in Germany, and he's judging it by the rebellion typification. That means that he's not applying the mutual recognition principle. So you cannot judge with the same standards two different things. So in Spain, for example, we have another crime that is if you help someone enter Spain illegally. So what happens if there is an Euro warrant about illegal immigration crime for a person that came illegally from Turkey to Greece and then from Greece to Romania, and a European citizen helped that person to go through those places. So if a Spanish judge says illegal immigration means when you help someone enter the Spanish territory, that person, of course, hasn't come to Spain illegally. So even if the crime exists, but one of the requirements is not complied with because the person is not entering Spain, of course, they will rule that this crime does not exist. So another question is why the European authorities did not follow the advice of the Spanish authorities. And 48 hours after the harmful question was considered, the first ruling of the Court of Justice of the European Union recognized the active legitimacy of the national authorities that sent the Euro warrant for a harmful question. So we lost golden opportunity there. Because the same thing happened when we waited 3 hours to issue the detention, the warrant, because maybe the result wouldn't have been the same, because Schleswig-Holstein made 2 referendums before the World War I in order to let them decide whether they felt Danish or German. So of course, pretending or trying to have them help us is very difficult. So someone should have warned the CNI to wait for 3 hours so that he would have gone to another land where the result might have been different. And we also lost a golden opportunity. We missed the opportunity. Well, we still have time because the directive that regulates the in absentia trials has not been transposed. So in this case, it cannot be judged because it's only for minor crimes or minor offenses. So the directive says what guarantees should be respected for this type of cases instead of categorizing the crimes in more important or less important, but that discretionality is very strict. I want to give the floor to Ruth. I want to repeat your question. I want to repeat the same question, but first of all, congratulations for your speech. And I wanted to ask whether the Euro warrant wouldn't have included the term rebellion, just embezzlement. Would it be enough? The German court said if it was just for embezzlement, the Euro warrant could have been applied. So that was a mistake on the part of those who issued the Euro warrant. What if you say that the Spanish prosecutor shouldn't have included the crime of rebellion? This is not for me to say whether that was right or not. Yes, but since you have an open procedure for disobedience, embezzlement, and rebellion, it would have been weird to issue Euro warrant for an offense instead of a crime. But because, of course, if you issue a Euro warrant for embezzlement, then if you get him extradited, you could have only judge him on that crime or that offense, embezzlement. Any more questions?
Sí, Poli.
Polly.
Felicidades, Alejandra, ha sido estupendo.
Congratulations, Alejandro. Thank you for the conclusion, because it was like a closing remark of everything that has happened here for 3 days. Thank you for the reference to Brexit. I don't know if you made it personalized. And I wanted to ask you, maybe you said it, but I'm a bit absent-minded today. I wanted to know the conclusion of the RO ruling in the case of the UK courts. To sum it up, the Court of Justice, the European Court of Justice, says that until the effective withdrawal of the United Kingdom, we have to keep on applying the law. You cannot sever the ties that might not be broken ultimately. So the argument of the lawyer did serve no purpose. So the criminal cooperation with the UK is maintained, but if in the future we consider that the UK is not going to respect the fundamental rights in the European Charter, the Euro warrants could be denied. The Euro warrants issued by the UK could be denied. So we could consider that the fundamental values are not respected because the criminal law in the United Kingdom is going to be modified, and also because maybe it is not going to maintain or to fulfill the values. So Teresa was saying that there was no articles on the withdrawal of a member country, of a member state in the Human Rights Convention, but yeah, this is just a hint. This is not serious enough for it to be considered as a possibility right now. Any more questions?
Bien, si no, como...
Well, otherwise, since we are now getting closer to the time of the closing session, I want to thank again all the speeches that we have heard, and I want to insist upon the fact that it was an honor for me to be in the seminar with Marcelino Oreja and Mr. Ambassador Bassols and all the rest, and we've been paying close attention to the process of the European integration with high passion. Thank you.